A very warm good afternoon to all of you. I am Pratyush Kumar, Research Associate Law at National Law University, Delhi. I shall be dealing with the module on sanitary and phytosanitary measures agreement under World Trade Organization. Now, with the standardization of norms under WTO, there was also increasing standardization of what kind of restrictions which could be placed or what kind of exceptions which could be invoked. Now, because of GATT, arbitrarily high tariff measures could not be invoked. Now, a higher customs duty also could not be invoked. So, countries developed other means of trade restriction, like having developed a complex set of norms relating to restriction of restrictions under sanitary and phytosanitary measures. Now, sanitary concerns animal life and health, including humans, and phytosanitary concerns plant life and health. The objective of this course of this module is to give an overview and functioning of the SPS agreement. It emerged out of the Article 20B exception under GATT 1994. The purpose of this chapter is also to give an overview of the jurisprudence of SPS agreement, which has evolved into a very complex legal scientific document and one of the areas where WTO member countries are again deeply divided. Why did such an issue creep into the world trading system? Now, the World Trade Organization effectively reduced tariff and then non-tariff barriers to trade. Market access improved significantly under GATT Article 3 through National Treatment Principle, GATT Article 11 quantitative restrictions, and tariffs were reduced progressively under GATT Article 1 of Most Favored Nation Treatment Principle, read with Article 2 Schedule of Concessions, which made it impossible for countries to use these measures for trade restriction. Then what was left for trade protectionism was using the exceptions under Article 20 of General Agreement on Tariffs and Trade, GATT 1948, which obviously was incorporated in GATT 1994, forming World Trade Organization in 1995 through the Marrakesh Agreement. Now, these exceptions were ingeniously used, or rather misused, by countries to restrict trade under the WTO regime, and this difference concerns national product standards. Obviously, human life, animal life and plant life and health are important, and they are important for all the different member countries of World Trade Organization, and the exception has to be used with lot of care and caution and should be used rarely so, though at the same time we have to keep in mind the biological diversity of the world. Now, what does GATT Article 20 say? Subject to the requirement that such measures are not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail, or a disguised restriction on international trade, nothing in this agreement shall be construed to prevent the adoption or enforcement by any contracting party of measures necessary to protect human, animal or plant life or health. Now, this became the foundational provision on which the entire SPS agreement evolved. Now, public health and health of the local and national varieties of plants and animals is of course of paramount concern to any member country, though it becomes insidious if its real purpose is to restrict trade, but it masquerades as a measure to protect human, animal and plant life and health. Therefore, an agreement needed to be reached which brought some level of semblance, uniformity, harmonization and predictability on issues of plant and animal life and health. Thus came about the SPS agreement. Now, what does it provide is a number of general principles, requirements and procedures which shall govern invoking of any protectionist measures under Article 20B read with the SPS agreement. Now, can there be a universal standard under SPS? Is it possible for all countries to have the same level of standards? Now, the recent restriction of mango exports, restriction of mango imports, rather exports from India and imports into EU were restricted because they were considered to be contaminated by pesticides. There are different health standards in different member countries. The more developed member countries have a more sanitized, more protected human, animal and plant life and health, whereas in developing countries the standards are not as high. Now, does it mean that there would not be any harmonization? Can there be any harmonization under such circumstances? Now, we will have to, which is why the SPS agreement was brought in, that some amount of semblance has to be reached. Now, a certain biological or chemical condition or usage might be absolutely benign or relatively benign in a certain geographic and climatic condition, but could be lethal in a certain different geographic and climatic condition, which is under article 6 SPS agreement. And this means that there could be a wide variety of variations even within a certain member country of WTO. For example, a certain pest might be absolutely ineffective or relatively less effective in a certain geographic climatic condition, but might be very active and destructive in a certain other geographic climatic condition. And any product standard which is evoked has to take all this into account by a WTO member country. Now, which are the organizations which would give the feedback for such international standards, if at all those international standards are reached? Now, as far as the prevailing conditions, there is no universal harmonization of standards, though we might be reaching towards it, but it has not been realized yet. Now, Annexure A of SPS agreement concerning international standards, guidelines and recommendations provides a list of international organizations which could be referred for setting up product standards for a relevant subject. The organizations are Codex Alimentarius Commission under the aegis of Food and Agricultural Organization of United Nations for Food Safety Measures, International Office of Epizootics for Animal Health and Secretariat of the International Plant Protection Convention for Plant Health. Other additional and relevant international organizations could be added to help develop international harmonization by the SPS committee established under article 12(1) of the SPS agreement. Now, what are the basic concepts under the SPS agreement? Now, under Annexure A again of sanitary and phytosanitary measures, any measure which is applied has to protect animal or plant life or health within the territory of the member from risks arising from the entry, establishment or spread of pests, diseases, disease carrying organisms or disease causing organisms. Now, the second thing is to protect human or animal life or health within the territory of the member from risks arising from additives, contaminants, toxins or disease causing organisms in food, beverages or feedstuffs. Third, to protect human life or health within the territory of the member from risks arising from diseases carried by animals, plants or products thereof, or from the entry, establishment or spread of pests, or to prevent or limit other damage within the territory of the member from the entry, establishment or spread of pests. SPS measures would include, it can include other areas as well, but some which we can identify are end product criteria, processes and production methods, testing, inspection, certification or approval procedure, relevant statistical method, sampling procedure, method of risk assessment, packaging and labeling requirement directly related to food safety, quarantine treatment. Therefore, what we observe is what the intent of the measure is. If the intent is to protect plant, animal or human life and health, it would fall under the SPS agreement. If the intent is not to protect against one of the risks, it becomes trade restrictive and would not be a sanitary or phytosanitary measure. Some salient features of SPS which could be identified are: SPS agreement applies to measures which have trade effect. Article 1.1 scope and coverage of the SPS agreement. Article 2.1 recognizes the rights of governments, including state and local governments, to take SPS measures. SPS measures can be applied only to the extent necessary for protection of human, animal and plant life and health, and must be based on scientific principles. Article 2.2 exceptions under Article 5.7. Now, what are these? There cannot be universal scientific principles, because each country also employs different set of scientific principles. For few countries, genetically modified food is not considered to be harmful based on their own scientific experiments, whereas there are other set of countries for which genetically modified products are considered to be absolutely harmful. Now, and so it leaves scope for greater growth in this field to reach a universal set of scientific principles, also determining what all requirements should be placed as as forming restrictions for products under the SPS agreement. Now, the next point, the term scientific is not defined in the agreement, but would generally signify a measure which is having or appearing to have an exact, objective, factual, systematic or methodological basis. Scientific certainty is rare, and SPS agreement gives room to differing scientific views by different governments. An example definitely comes to mind, like in 1920s and 30s, cigarettes were shown to be good for health, but then later on and there were experiments which would prove, I mean obviously those experiments are doubtful, could be spurious and could be motivated, but on the other hand then a global consensus was reached that yes, cigarettes are harmful for health. Now, similarly, reaching global standards for what is good and what is harmful for health also has its own set of pattern. I mean even digestion, or how human life and animal life or plant life functions in a certain topography and functions in a different topography varies. They could be more susceptible to diseases in one set of circumstances as compared to another, or they could be more susceptible to certain germs and not to other. Now, in this light we deal with the case of Japan measures affecting agricultural products. Now, the present dispute came in appeal to the appellate body from the decision of the panel, and there is a beautiful discussion of Article 2.2 and 5.1 in their relationship in the report of the appellate body. Brief facts: Japan had put in place a few quarantine measures for codling moth, which is a pest which invades apples, cherries, nectarines and other fruit crops. Under the said quarantine measures, any imported plant or plant product upon entering the Japanese territory have to be inspected by plant quarantine officers at one of the 101 major ports or airports of entry for any quarantine pest, in this case codling moth. In certain cases, a growing site inspection by the foreign authorities was also to be carried out. Japan also required each variety to be tested separately. Hereinafter, varietal testing method for codling moth, which was the main issue for the dispute. What were the claims of the parties? It was alleged by the United States, inter alia, that the varietal testing method used by Japan to screen certain varieties of products being imported from the US was inter alia violative of SPS agreement. Violative of SPS agreement provisions articles 2.2, as the Japanese varietal testing requirement was maintained without sufficient scientific evidence as mandated in article 2.2, articles 5.1 and 5.2, because the Japanese varietal testing requirement was not based on an assessment of risk as mandated by article 5.1 and 5.2. On the other hand, it was claimed by Japan that article 5.7 has to be looked into before any measure be called violative of SPS agreement, because of its non-conformity with article 2.2. Some of the key findings of the panel's report. After weighing the evidence put forward by both the countries, the panel concluded that though there might be varietal differences in plants, but they do not produce any difference in the test results done for quarantine risk assessment. So, the differences do not have any causal relationship with the results sought to be achieved. Hence, they concluded that Japan's varietal testing requirement is maintained without sufficient scientific evidence in violation of article 2.2. Again, with respect to article 5.6, the panel broke up article 5.6 to define a measure more trade restrictive than required if there is another phytosanitary measure which, reasonably available, taking into account technical and economical feasibility, achieves Japan's appropriate level of phytosanitary protection and is significantly less restrictive to trade than the varietal testing requirement. And as there was another method available, as was ascertained by various expert depositions, hence Japan was also held to violate article 5.6. With respect to article 5.7, the panel distinctly noted the requirements to invoke the said article, where relevant scientific information is insufficient and the measure is adopted on the basis of available pertinent information. In addition, the party is also under an obligation to seek to obtain the additional information necessary for a more objective assessment of risk and review the phytosanitary measure accordingly within a reasonable period of time. In the present case, Japan was unable to furnish any evidence which proved that it has met the obligations enumerated herein above. So, they held that Japan had violated article 5.7 as well. Article 2.3 actually reinforces national treatment and most favored nation treatment principle and wants to weed out obstacles to trade. Restriction have to be rarity and based on sound scientific rationale rather than as a rule. Now, we see the way the panel and the appellate body decided in this case, that there are obvious differences in terms of what scientific instruments, how those experiments are carried, what are the standards reached, and the standards could vary from one country to the other. Some might be more sensitive to the needs of their people, animal and plant life and health, whereas others are not or cannot afford to. Now, these issues definitely have to be dealt with in a greater detail, and it also affords opportunity for countries to reach or have a mechanism or have an international body to look into what should be the universal sanitary and phytosanitary norms. Now, that obviously would have the same developing country divide, but a meeting ground has to be reached to make trade more convenient, more predictable and more more development oriented for both the developing as well as the developed countries, and it has to keep in mind the health and well-being of the citizens, of the animals, of the plants and the varieties. Now, the next case we are dealing is Australia, measures affecting importation of salmon. This dispute, which was later settled between the parties by arbitration, concerned inter alia violation of Article 2.3 to the effect that Australia imposed stringent restrictions on dead imported fin fish purportedly to prevent the spread of disease, while imposing no restrictions whatsoever on the domestic movement of dead fin fish. The panel findings. The panel, while discussing the possible effects of Article 5.5 and 2.3, reiterated the appellate body in EC hormones and concluded that Article 2.3 prohibits two things: phytosanitary measure that arbitrarily or unjustifiably discriminate between members where identical or similar conditions prevail, and application of phytosanitary measures that would constitute a disguised restriction on international trade. And an important element of Article 5.5 is that it requires that the measure in dispute results in discrimination or a disguised restriction on trade. Hence, if this element of Article 5.5 is not fulfilled, automatically Article 2.3 will also be violated. In the present case, the panel reached the conclusion that Australia was acting in violation of Article 5.5 by violating all the three elements of the article, and hence by extension was violating Article 2.3. Appellate body findings. The appellate body, on the other hand, did not accept the above mentioned logic of the panel report and concluded that it would first of all be necessary to determine the risk to Australia's salmonid population resulting from diseases which are endemic to some parts of Australia, but exotic to others. But because there were no factual findings by the panel or undisputed facts between the parties on the matter, it was impossible to determine if the quarantine mechanisms constitute an arbitrary or unjustifiable discrimination within the meaning of Article 2.3. Compliance panel findings. The appellate body finds out clearly the identical or similar conditions that is to be compared here with the risk to salmonids and other fish population from imported fresh chilled or frozen salmon from Canada, with the risk to salmonids and other fish arising from endemic diseases. One finer analysis, the appellate body came to the finding that Canada was seeking equivalency of measures without assessing the risks. The domestic fish population that has been alleged to be unregulated were actually not disease causing at all, or at least they do not cause the diseases caused by dead imported fin fish from Canada. So, the appellate body held that Canada has the burden of proof to establish a prima facie presumption that different measures arbitrarily or unjustifiably discriminate between Australia and Canada in respect of the measures taken to comply, and that Article 2.3 first sentence does not impose a requirement of equivalence in measures. Now, the next point we have to deal in SPS is that it does not entail acceptance of downward harmonization. This is very important. Harmonization is a standardization of SPS measures which is acceptable by all member countries of WTO under international standards, guidelines or recommendations by any government, which is covered under Article 3.3 of the SPS agreement. Individual countries can and do have their own standards. The next point is, if a national measure is in conformity with international standard, measure or guideline, it is deemed to be necessary and it is considered to be consistent with GATT 1994 covered under Article 3.2 of the SPS agreement. Now, under Article 4.1 of the SPS agreement, if the exporting country has the same level of protection as the importing country, then they reach an equivalence, but such equivalence does not violate against the importing country's right of inspection, testing and other relevant procedures to establish equivalency. Article 5.1 requires each government to ensure that its SPS measures are based on risk assessment. Annexure A provides a general definition of risk assessment. When a member country conducts risk assessment, it has to take a number of factors into consideration. Under articles 5.2 and 5.3, like available scientific evidence, relevant processes and production methods, relevant inspection, sampling and testing methods, and relevant ecological and environmental conditions. Another very important case that we will deal with is Japan measures affecting the importation of apples. Now, on March 1st, 2002, the United States requested consultations with Japan regarding restrictions allegedly imposed by Japan on imports of apples from the United States. A brief introduction of facts. The present dispute, which was again settled between the parties, arose out of quarantine restrictions imposed by Japan on imported apples for protection against introduction of fire blight. The quarantine restriction consisted of prohibition of import of apples from orchards which were fire blight, would be detected during 3 tests conducted in a year, and also if they were detected within a 500-meter buffer zone surrounding such orchard. Article 2.2, on the question of burden of proof, Japan seemed to be harping on the proposition that US could not prove anything in apples other than mature asymptomatic apples, and hence have not made a prima facie case against Japan. The appellate body held that it is sufficient establishment of prima facie case if the normal imported product has been proved to be subjected to arbitrary and trade restrictive phytosanitary norms. Further, the appellate body also noted that it is not essential for the panel to judge the sufficiency of scientific evidence from the point of view of the importing country, and they can easily rely on the opinion of experts in the field. Hence, the panel's findings in that Japan's sanitary measure at issue is maintained without sufficient scientific evidence within the meaning of article 2.2 of the SPS agreement was upheld. Now, article 5.1, specificity of risk assessment. The panel found the risk assessment not sufficiently specific because it did not purport to relate exclusively to the introduction of the disease through apple fruit, but rather more generally, apparently, through any susceptible host or vector. In this case, the appellate body reached the finding that because the spread of the disease varies significantly depending on the host and vectors, so the risk assessment undertaken for apples only, which were only one possible vector for fire blight, were not sufficiently specific. So, the evaluation of the risks do not qualify as risk assessment under the SPS agreement for the evaluation of the likelihood of entry, establishment or spread of fire blight in Japan through apple fruit. Articles 5.4 and 5.5 of the SPS agreement provide minimal disciplines for establishing levels of protection. Article 5.5 further provides that an SPS committee established under SPS agreement should develop guidelines to further the practical implementation of that provision. Under article 5.6 of the SPS agreement, member countries shall ensure that such measures are not more trade restrictive than required to achieve their appropriate level of sanitary or phytosanitary protection. taking into account technical and economic feasibility, measures achieving the appropriate level of sanitary or phytosanitary protection and is significantly less restrictive to trade. The complaining members would have to show three preconditions to prove that the concerned country enacting SPS measures is more trade restrictive than required under the explanatory footnote to article 5.6. A specific alternative measure was reasonably available, achieves the level of protection the concerned country determines is appropriate, and the alternate measure is significantly less restrictive to trade. Under article 5.8, the importing country is obligated to provide on request an explanation of the reasons for its SPS measure. There are also transparency requirements under the SPS agreement, which is covered under article 7 and annexure B, which where concerned parties get to know what requirements apply and how to adapt production and other activities to the said requirement. Annexure B requires all governments to publish SPS measures promptly. Those SPS measures which are not based on international standard should be provided to other members on an advance notice and an opportunity to comment on the proposal, except where some urgent problems of health protection is involved. Time should be allowed for producers in exporting countries to harmonize their products and methods of production to the proposed SPS measure unless it is urgent. Then article 8 and annexure C provides specific disciplines on control, inspection and approval procedures. So, what we notice in SPS agreement is that there is huge scope for growth, there is huge scope for reaching harmonization and standardization globally. There is scope for having such a body which would determine international norms, which would determine what should be the standards applied under the aegis of WTO. So, if all this should have been taken up during the Doha rounds, and I am sure they were taken up, but if again WTO would engage in having its new round of negotiations, these issues should certainly crop up and should certainly be addressed. That some world body or a scientific body under the aegis of WTO should be developed, which should look into these issues. Then again there is another question, that can WTO as an apex body determining world trade determine issues relating to individual scientific standards, relating to protection of animal, plant and human health within their own respective domains. There would be issues of sovereignty, there would be issues of because so many member countries, and within member countries also so much of diversity in terms of geography, topography, climate, biodiversity, all that will have to be taken into account in order to reach a standard. All the information will have to be first collated, collected, and also at the same time it will also have to have some open ended ways of looking at things, because the entire biological diversity of earth hasn't really been fully known, fully captured and fully understood under a scientific parameter. So, if such a body is reached, if such a body is authorized under the aegis of World Trade Organization, there could be scope for even greater scientific advancement for protection of better protection of animal, plant and human life and health, and also in saving the environment and protecting biodiversities across the globe. I hope my lecture on sanitary and phytosanitary measures agreement this afternoon has been helpful in understanding some of the basic concepts regarding what is SPS agreement, how it pans out, what are the issues therein, how WTO member countries are trying to resolve their disputes, and also how it creates opportunities for us to move forward in terms of if there is a new round of negotiations initiated under the aegis of World Trade Organization, what are the issues which could be taken up, and how a new set of policy and a new set of legal regime for WTO and with regard to sanitary and phytosanitary measures agreement could be taken forward. Thank you.